In my 8 years in wealth management, there is one story that still haunts me. There's a man, he was the father of one of my clients. He had passed away, thinking he had everything in order. His children thought the same thing. He'd updated his will after a divorce, making sure his new spouse and kids were protected. But when the dust settled in his estate, his entire 401k, over $600,000, ended up with his ex-wife. One small overlooked detail completely unraveled his plan. And here's the truth. Even if you know your beneficiaries are right, you could still be making a similar costly mistake. Because a 401k isn't just about who inherits, it's how they inherit. So in this video, I'm going to show you how to protect your family, cut unnecessary taxes, and make sure your money lands exactly where it belongs. No surprises. If you're new here, hi, I'm Rachel Camp. I am a CFP professional and the founder of Camp Wealth, and we help people confidently retire before age 65. So let's dive in. The first thing you need to know about your 401k is that the beneficiary that you have listed on your account will override whatever your will says. Even if you have a well thought out and detailed will that lists your beneficiaries, specifies when they get the money, has all types of great detail, the beneficiary designation basically takes that will and says, I don't care. Not actually, but in the hierarchy of estate planning, what you need to know is it goes beneficiary designation first and then your will. The beneficiary designation, it carries a lot of weight and it's almost impossible to override, even if you're pretty confident that the listed beneficiary is outdated and the decedent would not have wanted their assets transferred to them. Like the story I mentioned earlier, if you go through a divorce, please double check your beneficiaries. This is the case that I've seen happen way too many times, is outdated beneficiaries. And this is why your estate plan is only as strong as its weakest link, and updating your will is not enough. You're not done. Your beneficiary designations need to align with your overall plan, especially as your life changes. So that is who gets the money, but now let's talk about how much they actually get. Because taxes, they can take a healthy bite out of your legacy. And thanks to a recent law change, it could be worse than some people are thinking. The second thing you need to know about passing on a 401k is that stretch IRAs are gone. Tax strategy matters a lot more under these new rules. Under the new Secure Act, non-spouse beneficiaries now have to withdraw the full 401k within 10 years. This is a big shift from the old stretch IRA rules where they could take distributions out of the account over their lifetime. If your kids inherit your 401k or IRA in their peak earning years, they might get slammed with taxes. But you can start to be strategic now. The account types we've been talking about so far are what we call traditional 401ks and IRAs. And the way that these traditional accounts pass on is you avoid tax as you put the money into the account now, you get a tax deduction, and then you'll pay tax later when the money eventually comes out. With a Roth 401k, on the other hand, we don't really have to worry about this problem because your kids will inherit Roth accounts tax-free to them. All that money that comes out of a Roth should be tax-free. It's an incredible account type to pass on. But with traditional or pre-tax accounts, the strategy really starts now while you're still living. Strategic planning involves asking yourself, would it be better if I start doing Roth conversions while I'm in a lower tax bracket today versus your children's potentially higher tax bracket when they inherit? Picture this. You leave a $500,000 401k to your adult son. Let's say he's single and making $180,000 a year. Because of the 10-year rule, he has to drain that account within a decade. Now, if he spreads the withdrawals out evenly, that's about $50,000 a year added to his income. We're ignoring market fluctuations in this account too. But that extra $50K a year for him will actually bump him into a higher tax bracket. You see, right now, with what he's earning, he's at the top of the 24% bracket before he adds any of that money from the inherited IRA. So adding that $50,000 a year will actually bump him into the 32% tax bracket, which is a big leap from 24%. And most of that $50K will be taxed at that higher rate. That is a six-figure tax bill over those 10 years for him. Remember, you're not just planning to pass on money, you're planning to pass on tax-efficient money. Every dollar sent to the IRS is a dollar your loved ones won't get. I'm sure they appreciate it anyway, despite the increased taxes, but smart planning can make a six-figure difference for them. More money for your family, less in taxes. If that surprised you, it actually gets a little trickier when spouses are involved. Because in many situations, your spouse is entitled to your 401k first, even if that's not what you want. So let's look at this overlooked detail. Point number 3, most of the time, your spouse is the default beneficiary on your 401k. If you want to name someone other than your spouse as a 401k beneficiary, depending on your state, you may actually need their written consent. So they actually have to sign off on it. I see this become really important for blended families where you are both coming into the marriage with kids from other partners. If you are remarried and you want to leave assets to your kids from your first marriage, you have to get the paperwork right. The default setting of everything going to your spouse might be fine for you, but double check the default setting to make sure it is what you want. What I've seen happen occasionally is the 401k owner passes away. The account is inherited by the spouse in the second marriage, and then when that spouse passes, it actually goes to their kids instead of the original 401k owner's kids. Let's say Sarah is remarried and she has 2 children from a prior marriage. She wants her 401k to go to her kids, not her new spouse, so she lists the kids up as beneficiaries, but never gets her spouse's written consent on this. When she passes, her new spouse could actually argue that that 401k is his because he never consented to the beneficiary change. Her kids could potentially be left out, even though that's not what she wanted. If you don't want this, you need to make the adjustments now. So yes, your spouse is usually the default beneficiary on your 401k, but here's where things get a little nuanced. When your spouse inherits the account, they actually have 3 options available to them, and this is new. That new third option adds a little bit more flexibility. So for many people, they do want their spouse to be the default beneficiary. So now we have to look at how the spouse inherits. And what the surviving spouse chooses can have huge implications for taxes, RMDs, and even what gets passed down to your children. So let's break this down. Pre-2024, spouses who inherited a 401k had 2 simple options. They could take the account over as their own, or they could keep it as an inherited IRA. Each had trade-offs depending on the age of the surviving spouse, but most of the time, the simpler and better option was just to take the account over as your own RIA. But in 2024, a third option came into play under Secure Act 2.0. A new election just for spouses, it creates kind of a hybrid approach to the previous 2 options and can be incredibly powerful in the right situation. Imagine your spouse passes away at age 62 and you are 58 years old. You inherit their 401k with $500,000 in it. You roll it into your own IRA. You are treated as owner, which is great, except you can't access that money until age 59 and a half without penalty. So you might think, okay, we'll go to the second option. We'll leave it as an inherited IRA. So yes, you can access the money penalty-free now, but you will probably have to start RMDs early, and they'll be calculated using a more aggressive table, which just means higher taxes for you. Now, here's where the third option might work for you. You can choose to be treated as if you were your deceased spouse, which sounds weird, I know, but it has 2 key benefits. First, if your spouse wasn't yet taking RMDs, you don't have to start either, even if you are older. Second, when you do start, your RMDs are calculated using the owner table, which means smaller withdrawals and more tax deferral. Each option has its own set of rules around when RMDs begin, which table you use for calculating the RMDs, and whose life expectancy to use. Oh, and rules change a bit depending on if the deceased spouse had already started RMDs or is yet to start. In other words, incredibly simple. When I saw the new rules, I thought, okay, well, that's at least job security for me. But what I will say is most of the time, taking the account over as your own is the best and simplest option. The other 2 options become intriguing if there is a large age gap between you and the spouse who passed, either much older or much younger. That's when you'd want to start looking at another option. All right, so you have some idea of what happens when your spouse inherits your 401k. Great. But what if something were to happen to both of you? Or let's say you're single and your primary beneficiary is your children. I find almost no one knows this, but if you have minor children younger than 18, you need a plan because children cannot directly inherit your retirement accounts. If you name your minor children as primary beneficiary or contingent beneficiaries, they are going to have a difficult time because they can't legally inherit the account until they are 18 years old. This means court steps in, appoints a custodian, and that's where things get really messy. Instead, you could set up a trust for your minor children, name the trust the beneficiary. This keeps the courts out of it. But this is a really complex topic, and there are several things to think about with account types and state laws. This is actually an area you should consider hiring legal expertise to help to make sure you get this right. Now, we've talked about how inherited accounts are treated, but here's something that trips up even the most organized retirees: forgotten 401ks. Old accounts from past jobs might be floating around with outdated beneficiaries. Let's wrap this video up with a fix that's simple, powerful, and often overlooked. If you've had multiple jobs, you might have a few 401ks floating around. And guess what? Those 401ks will have whatever beneficiary you listed at that time, potentially decades ago. Track down those old 401ks and let's consolidate them. You can roll them into an IRA or into your current 401k if your plan allows for it. And then you can be sure that it's in an account with the correct and updated beneficiaries on them. Old forgotten 401ks are where I see some of the messiest estate problems. Simplification and consolidation isn't just an effective wealth building strategy, but it's peace of mind both for you and your loved ones when you pass. There is an estimated 29 million forgotten 401ks holding an estimated 1.65 trillion in assets. Go get your money. After you pass, things don't magically take care of themselves. If you aren't proactive and clear, your loved ones will be left guessing what your intentions were, paying unnecessary tax and fees, and potentially fighting it out in court and ruining their relationships. I'm not being dramatic here. I have seen it happen to families that I thought had a 0% chance of ever being torn apart. If you are ready for help aligning your 401k and your estate plan the right way, check out the link to Camp Wealth below. I help people retire before age 65 and make smart, tax-efficient decisions every day.